morning.
Here.
Yes, that's good. Good to see a bit of rain.
Yes.
Would you please introduce yourself and give us a bit of your background?
Yes, Rick, thank you for having me today. First of all, I'd just like to acknowledge the new facilities here in Boonah that the Churches of Christ have built. Exceptionally beautiful, the grounds, the rooms, all the amenities that they're now providing here. Absolutely beyond excited for our community and people who move here to join.
Thank you, Ricky. We're very proud of the place. It's got a real good soul, this building.
Yeah, really calming. It certainly does not feel like you're here in a village. It really feels like you're away on a holiday. Firstly, about myself, I would just like to mention that we've been in the Scenic Rim now for approximately 5 years. We've purchased a 200-acre property down near Rathdowney where we breed Droughtmaster cattle. So not only do we have the business up here that I love dealing with the community, we also run a lot of cattle who are all calving at the moment, so that's really great to see. Before moving out to the Scenic Rim, I worked as an associate on the Gold Coast at a legal practice there and have been in the legal industry throughout my whole working life, all for about 5 years. So I've got well over 20 years experience. Today we're going to be talking about wills, powers of attorneys, advanced health directives and probably in that order as well. If anyone's got any questions, like we said, we can text you through. You can text through questions to us, and I'll be happy to answer them as best as I can. Boonah Law Practice has been in the district for well over 100 years. Initially was run by Richard Darville's family, and upon working with him for some years and on his retirement, I took over that firm for him. So we're happy to continue providing Boonah with all of their legal concerns associated with estate planning as well as properties. I'll start with talking about wills. Although before we start, I would just like to focus on the fact that what we talk about here today is general. It's not specific to anyone's circumstances. Anyone specifically with any concerns should take their own advice in that regard. We're just going to give you a general idea so that people understand and know what these things do, how they work, why they're good, where any complications may rise. So initially when we're discussing wills, often people do ask, why would I do a will? I have little assets to distribute, so they may not wish to do it. But what people don't realise is that a lot of your other wishes are also included in will. So it's not just about what you want done with your assets. Your will can have in there how your body, what you would like done with your body after you pass away. How you might like your funeral or where or whether you want to be buried or cremated and things to that effect. Now, with respect to funerals, your executor, who you nominate in your will, does have the power to override those requests, but generally speaking, that doesn't happen. If someone puts their wishes in the will, that will be followed. The only exception to that rule is if you have a specific request not to be cremated, an executor cannot override that. That is the one rule in that. You might also have children that you need to appoint guardians for. You know, you might have life tenants, you might want to have a life tenant in your property. So all of those types of things are actually provided for in a will in addition to what your assets and distribution of those. One common question that I do receive about when somebody passes away is, do we pay death taxes? And that's a big no. So in Australia, death taxes haven't been around for some time. So there's no death taxes in Australia. What we can't distribute in a will, jointly owned property is one of them. So if you own a property jointly with your partner or anybody else, those things cannot be gifted to somebody else in a property. By law, they will automatically revert to the survivor. When you own property though, you can sever that tenancy so it's not jointly owned, and you own it in what they call tenants in common. If you do own property as tenants in common, then you can gift your share in that property to somebody else through your will. It does not automatically go to the survivor. If you're selling property and you've entered into a contract to sell that and then you pass away, that property cannot then be gifted in your will because you're already under a legal obligation to sell that property, and your executor will have to continue on to see that contract to an end. Property that you might own in a trust, a family trust or any other type of trust, cannot be gifted in your will. So often for asset protection, people will create trusts, but they still think that it's their asset to be able to distribute in their will. It's not. The asset that's in the trust will be dealt with in accordance with the terms of the trust, and therefore they do not get included in your will. A big one that a lot of people are not aware of is that your superannuation does not form part of your estate, and you cannot distribute it in your will unless there are certain circumstances. So superannuation, you enter nominations with the superannuation companies, and there are two types of nominations in that regard, a general nomination and a binding death nomination. So you've got to be really careful when it comes to superannuation, and that's something that everybody should discuss with their legal advisor when they're creating the will. Because generally speaking, that superannuation and the insurance that's attached to it is often the most valued part of a lot of people's estates. And if it's not dealt with properly, then there can be issues. So that's one point to consider. The first thing that we normally look at or discuss with a client when we're looking at creating wills is who you would like to appoint as executor to manage the affairs of your estate when you pass away. Careful consideration must be made when you're appointing an executor in this regard, because that person, you must have faith in their ability to be able to call in your assets and to distribute them in accordance with your will. Now, some people you might be very close to, but they, in dealing with your death as well as having to call in your assets and distribute them, and also if there's going to be somebody contesting your will, that person is going to be in charge of dealing with that. So be comfortable with the person that you are appointing and ensure that they're going to have competency to actually process. An executor can be a beneficiary of the will, and in fact, if you are creating a will and you've got, let's just say, two beneficiaries who are of age and they're competent people, there would be no reason why you would appoint somebody else other than one or both of those beneficiaries, because they're the ones who are essentially going to benefit from the estate, and therefore they're going to be doing the best things in their favour. It saves time, resources and money.
Can I ask you a question
Sure.
there? Is it possible to have multiple executors,
Sure.
executors, within the family?
Sure, you can have up to 4 executors.
And why would you do that?
Well, if there are 4 beneficiaries, you may wish to have all 4 of them have the ability to make decisions on what happens with the assets. If you have 1 or sometimes even 2, you should also think about another substitute executor in the event that one or both of those people have passed away before you do at the same time, or even if one of them renounces because they do not wish to attend to those affairs. So any executors appointed are appointed to act jointly. They've all got to make decisions between themselves unless you make them in consecutive order.
Right, okay, thank you.
Pleasure. Now, Executors Commission. Usually most executors are happy to deal with the estate on the basis that they're receiving a benefit under the will in any event. But executor's commission is available for people to claim as an executor, and generally that commission would be guided by the court. If the beneficiaries, however, agree to a figure, or if it's stipulated in the will on what benefit that executor should receive, then an executor is entitled to their commission. It's not common, as in an everyday event, that we see executors claiming commission, but definitely when estates are are very complicated, they go for extended periods of time, and executors then, should receive some compensation for their work that they've done there.
Riki, can you provide an example of what that commission might be? Are we talking a lot of money here?
Look, it depends on what the estate consists of, and it is worked, but if you generally say between 1.5% and 3% of the estate, as a general rule, but it depends on the circumstances, how much effort's been involved, and each estate we look at on an individual basis. One other thing that we look at when we're doing or creating the wills is personal effects, because often people are interested in what we're going to do with the larger assets, but often some of these personal effects are more personal and to people who know that person, who might have gifted those things to those people. So we can actually distribute specific items through the will, or we can give the executor the ability to take the assets and distribute them in accordance with how they think that they should be distributed. So for example, if the executor was given that ability, they might call in the family and the family gets to choose between the personal items. No dollar value really on these things, but sentimental.
Is there a process that the executor has to run with the family at that stage? So if there are 3 daughters in the family and they're all due to inherit something, that's right, and they want that same thing, how do they work that out?
Well, ultimately it's the executor's decision. So they make that. If you give the executor the ability to, in the event that there is a dispute, the executor makes that final decision. So then we think about who beneficiaries and who we're going to nominate as beneficiaries. So first of all, to receive a benefit under a will, a beneficiary has to survive you by 30 days. That's by law. So that's one thing to consider. The other thing to consider when you're thinking about beneficiaries is what happens. I'm gifting you something in my will, but you pass away before you get the benefit. So what do you want done with that asset? So that's another thing to consider when you're drafting a will is what happens if someone passes away? Is it just going to go back into the rest and residue and go to the surviving beneficiaries, or did you want that particular thing to go to somebody else in the event that one of the beneficiaries has passed away? Consider what effect that gift is going to make on that beneficiary, particularly if that beneficiary is getting some sort of government assistance, because it may actually disentitle that person from getting their benefits, or even just reducing it. So in effect, it could harm the benefits that they're currently receiving. If you're liable for capital gains during your lifetime on any assets, that capital gains is still paid through the estate and will carry on to any beneficiaries. So that's one particular thing that you would need to take into consideration, because if you're gifting things on the amount of value and you're trying to make it fair, and some assets are worth approximately the same amount, and some have capital gains and some others don't, then you might be unfairly distributing, which was not your intention. Legacy to minors. You can gift to minors, although they do not take those gifts until they turn 18, or people might wish them to take them at an older age, and that's completely up to you. You can actually provide that in your will. If you do leave gifts to minors, generally speaking, your executor will look after that until that person takes control of the assets. So you can appoint somebody else for a specific gift. So if you're gifting to a grandchild, you might wish to give it to their parents to look after for that child, or you can just keep it with the executor if it's not one of their parents. When you sign in a will, you do need to have 2 witnesses there. That is, and particularly 2 witnesses that are not getting a benefit under the will. But once you sign that will, it is imperative, and we'll speak about that when we get to probate, that you don't make handwritten amendments on the will, even a copy that you've got at home. You don't want to be making any amendments to that will, because it can be seen that your intention is to change that will, even if you were just making notes on it. So put it away, bring it out every few years, check it, make sure it's still got your wishes. If you want to make any amendments to it, you do want to go back and see whoever prepared it for you in the first place.
Riki, you mentioned every few years it should bring it up, but is there a time where it's the right time to do to refresh your will?
Look, if anything substantial happens in your life, or there's a substantial change to you or a beneficiary, then that's the time to bring it out. When you do when you do binding death nominations with superannuation, they have to be renewed every 3 years. So it's a good idea, if you have one, when you are renewing it, pull your will out at the same time, review it. I would think every 3 years, just have a scan over it, but definitely if something substantial happens. Because if you marry somebody and you do not create a new will, your existing will is invalid. So it just cancels out. So if you marry, you want to change it. If you divorce, you need to relook at it. Although the will not be invalid if you divorce, it is invalid to the extent that it deals with your ex.
Sure.
So the whole structure of the will would change, and it gets extremely complicated. So that's one thing that you need to. If somebody passes away, obviously you would want to look at it. If you win a lot of money, so just any significant circumstance in your family, that's when you would want to relook at your will.
Okay. Next time I win the lottery, I'll come to say that.
That would be good. Now, so actually that was the next thing that I was going to discuss, when to reconsider doing your will. And I don't think I left anything out there. One other thing is children. So if you have children that were not dealt with in your current will, then you might want to redo your will to include those children. Or if you didn't have children at all in your will, and now you've got children, then obviously. So any big changes in your life. Also, if you've sold property that you were gifting to somebody and you want them to benefit in some other way, obviously you'd have to relook at that. So I hope that deals with wills.
That's the end of
very
the wills
well.
for the moment. Okay,
Yes.
Thank you very much, Riki.
But the next part of wills is, once you pass away, what happens with that will. So that's where we're going to move on to probate. Probate in Queensland is not compulsory, and we'll deal with... I'll actually start first of what probate is. So probate is where the will goes to the court, the Supreme Court in Queensland, and they actually assess the will, the death certificate, and they actually make sure that that the will complies with the Act, it's being created correctly, and if there is any evidence that that creator of the will did not have sufficient capacity to make that will, then that might show up on a death certificate and things like that. So, but what the will actually does is, the will itself gives authority to the executors. So that authority is derived from the will. But what the grant of probate does is it actually proves your authority. So it gives official recognition to the executors named in the will that they have a right to administer the estate in accordance with the terms of the will, and provides not only the executors but also anybody who acts on instructions from the executors protection against their actions. So one question is, you know, how much, I mean, it is an expensive process to get probate, so you're probably looking at somewhere between $3,000 and $5,000 to get through that process for probate. But probate's not always required in Queensland. You don't need to get probate if you're just dealing with property and assets of a smaller value, but once you go over that $50,000 mark in cash value, that's generally when you'll see that you'll need to get probate, because a lot of institutions will not release those monies to the estate until that will has been proved by the court. Right. Now, the order in which things take effect, so there's not really anything we can do to obtain probate until the death certificate issues for the deceased. So the death certificate issues, and we also review that to make sure that there hasn't been anything noted on the death certificate with respect to a person's capacity or their understanding of entering into the will. Right. If there is, for some reason, we would generally get an executor, or we would write to the doctor of that person, just to, if we didn't know them quite well, to get an understanding from the doctor of, you know, when that might have came into effect. Would they have had capacity at that time? But if we have ever got any concerns when we're creating wills about capacity, we would certainly have that person go to the doctor and get a certificate first, to ensure that if somebody contests it and claims that the will's invalid because they didn't have capacity, we would have some sort of medical knowledge. In saying that, it's not up to the doctor and it's not up to us, it's up to the courts to determine whether they think that that person had the capacity to make that will. So receive the death certificate, obviously review that with the will. Then what we do is we advertise in the Queensland Law Reporter, and we have to write to the Public Trustee's Office to inform them that we will be requesting probate of the will, and that goes out to the community then, to anyone who might have any claim against the estate, so that they're given notice. Also with the Public Trustee, it just goes to them so that they can check their records to make sure that they haven't done another will in that process. So once we've done that application, and during the advertising period, we'll go ahead and we'll prepare affidavits and all of the documents required to submit to the court, and we will file that 14 days after we've advertised. So we're limited, we have to wait 14 days before that goes in. The time period to get that document back out of the court is anywhere up to 3 months. At the moment, they're really quick. They're coming back in about 6 to 8 weeks. So it just depends on the backload in the courts on how long that takes. So generally speaking, nothing will happen in the estate until we get that probate.
Sure. Riki, it's been a challenging year, and a number of small newspapers in the regional areas especially are closed right now and doing it pretty hard. But you mentioned about advertising in that respect, so how do you get around that if the local newspaper is closed?
Oh, sorry. Okay, we don't need to advertise in local newspapers. Okay. It just goes into the Queensland Law Reporter. So all solicitors' firms generally look at that, or should be looking at that reporter. And we also check our safe as well when we see those advertisements to make sure that we don't hold a more recent will as well. So it's calling on anyone who's got debts to the estate. It's also putting it out there that, you know, if you've got a will that's of a later date, you need to provide that to the person who's applying for probate. Now, so obviously once the will goes in there, the courts will always also review the documents. There are formalities that need to be followed when you're creating the will, and they're the things that the court also studies and looks for. Now, the court does have the power to dispense with some of those requirements, but they won't change the concept of the will. That's not their role. Their role is to try and adhere to what those people's wishes are. But if you send a will in with no witness or one witness, or if you haven't complied, then you've got to do another application asking for the court to use their discretion as they're given under the Act to dispense with those requirements. So it's not just a matter of getting the will and distributing in most circumstances. So another question about what happens if there is no will. And this is where even when people die without leaving a will and they do not have many assets, someone still has to administer their estate. So an executor, if there's no one's been appointed an executor, you have to apply to the court to have the power to do that. So it ends up being more costly than doing a will in the first instance for somebody to actually do anything with your assets, because people have, even bank accounts and motor vehicles and things like that. Without authority, no one has the ability to do anything with any of the assets, regardless of how small they are. So that's also the instance in the event that you have a will and your executor has passed away before you and there isn't a secondary executor in place. Again, we can apply for letters of administration, which is what that is called, and you can do it with or without a will.
Okay.
So if the will is attached, then the person who has applied to the court to be administers it in accordance with the terms of the will. If there is no will and you've got letters of administration, then the assets of the estate will be distributed in accordance with the Succession Act. So that depends on the particular person's family situation as to who benefits, but the Act provides on what the executor needs to follow. So in that regard, someone who you might not have wished to take benefit in your estate will, because the appointed administrator would then have to comply with the terms of the Act. So lots to think about with just a simple will, because a lot of people come in and say, I've just got this simple will, and when you start asking more questions, it actually becomes a little bit more complicated than you think. We're not trying to create issues, but we're trying to stop issues after you pass away in the event that you haven't given thought to specific things. So that's why it's always a good idea to go and speak to somebody about it, because, and actually I might just touch at the same time on will kits. Some people, well actually it's quite a common question that I get asked is, well, how good's a will kit? Now, a will kit's only as good as the person who's preparing the actual wording in that will. So it'll give you just a standard form for you to complete, but that form's not asking you questions or triggering you to different things. So look, I'd probably say, sometimes they work well, and sometimes they don't. So it just depends on who the actual person is who's completing it.
But any kind of complications at all, they're best to steer away from that, surely. And,
of course. And
come to someone like yourself.
Of course. I mean, I'm not sure how much those will kits are these days, maybe $50 or something like that. But, it doesn't cost all that much money to go and see somebody. Every law firm's going to be different on their fees. And if you really cannot afford to do a will, the public trustee do offer to do free wills for people. So there's always avenues or means to get them done if you need to.
Another little thing too, my mum passed away a few years ago in country South Australia, and because she had a long-term relationship with her local lawyer, when the family, myself and three sisters, turned up, it was just so much easier because there's a relationship there, everything had been considered, planned and organised.
Exactly.
And it's terrific.
And it's one thing that we try and build, and what we're actually trying to focus on at the moment is getting these young people into us, because I think that they believe, and when I'm saying young people, I'm talking 18 years old, because you've got to be 18 to be able to create a will. But anywhere between that 18 and 25-year-old period, because some of these people have just left school and the last thing they want to do is walk into a lawyer's office. But we're really friendly. We're mostly approachable, friendly. We want to get them in there and get them to feel comfortable with us. Often we're dealing with their parents and or their grandparents as well, and we know how the family dynamics are. We understand what their concerns of the family are, particularly out here where we've got a lot of family farms and businesses. So, coming in to do a really basic will for someone of a young age is really important, because not only are you, only in the last couple of years we've seen some really young people unfortunately pass away in our community, and working in a very difficult situation with grief, people are left with no ability to make decisions for the estate. So, but that aside, just to start building a relationship with somebody in the community who you can go to then whenever anything, you pick up the phone, they know who you are, and that extends to other issues outside of wills and estates and things like that. So just getting people to feel comfortable about, dealing with us. So that's something that we're actually trying to work on at the moment, is
good idea.
Pushing those young people in. Because even though it's important at any age, and I must say, I'm amazed at how many people come in who are even over 60 who have never done a will before. So get on there and do your wills. I know it's something that people are afraid to do, because, or not even afraid, but they just feel like they don't need it because they've got time to do it. But we just never know. We never know when you're going to need it. If we all knew that, we'd all be rich, wouldn't we? So,
that's right. But life's hard enough and complex enough as it is already. So if you have a relationship with someone in the law practice, it's got to help.
It most definitely. Most definitely.
Sorry.
No, you're right. But that's pretty much what I've got to say about wills and powers of wills and probate. So
my next question then is the enduring power of attorney.
Enduring powers of attorneys.
What are they and why do we need them?
Well, enduring powers of attorneys, first of all, I'll just start with, there's two different types of powers of attorneys. There's a general power of attorney and there's an enduring power of attorney. Now the difference there is that a general power of attorney will actually cease in the event that you become incapacitated. So a general power of attorney would be used in the event that you have business or financials, or you travel a lot overseas, so you want to give somebody direction on what to do on specific financial arrangements. And they're actually used, if you're going overseas and you've got your property on the market, you might appoint someone to act for that specific thing. But if at all you became incapacitated, that general attorney will cease. An enduring power of attorney is different in that an enduring power of attorney can start either immediately or on a particular date, or only in the event that you become incapacitated. So with respect to financial matters, that's the case. With respect to personal and health matters, it will only ever start when you become incapacitated. And all of those are dealt with in an enduring power of attorney, as opposed to a general power of attorney which only deals with financial matters. So it's a two-part section. You can appoint someone just for financial, or you can appoint somebody for just personal and health matters. You can combine the two, or you can separate it and have one person that deals with your financial matters and another person who might deal with your health matters. So if you appoint somebody as your attorney in that regard, they can do, without restricting it, anything that you can legally do yourself. So that person, apart from making your will for you, so
Okay.
that person really steps into your shoes to make decisions for you, whether it's selling property, doing your banking, paying your bills, or in the event that you become incapacitated, make decisions about your care. So it is really important, and I cannot stress this enough, that if you are appointing somebody, you have to have implicit trust in that person, because that person is going to have control of all of your bank accounts, all of the property that you own, virtually any assets. Now, you can make restrictions to that power of attorney so that it doesn't apply to some things, but when you're appointing somebody, you want to make sure that you have the utmost trust in them. The court does have the ability to ensure that your attorney is acting correctly, but often by the time anyone knows that anything's been happening improperly, the money's gone. So that person might get in a bit of trouble, but you're never going to get that money back. So you have to make sure that you trust that person implicitly. You can appoint more than one attorney, and you can actually have them sign jointly or severally, or if you appoint, say, 3 attorneys, you can have them sign so that they sign by majority, so that you've got more than one person making decisions for you.
Is there a situation where attorney powers of attorney, if they're multiple, if they're 2, could they contest each other's decision in court?
Oh, well, if you have, definitely. If you've appointed 2 attorneys and they both need to sign, then and if there's a dispute on what needs to happen, then it could end up ugly. So the other thing is you want to make sure that your attorneys are going to be able to work together, but keeping an eye on each other at the same time. So it's very specific to individual situations and the dynamics and the people who are around you as to who you might wish to appoint.
What are the limitations on being an enduring power of attorney? Do they have to be 18 years old?
18.
Like
you cannot be bankrupt. You cannot appoint someone who's bankrupt. But anyone over the age of 18, generally it's a good idea to have someone who's local, who knows you, who knows what your wishes would be. Because, like I said, that person is really stepping into your body and making decisions for you. Unless you actually specify in there what particular things that you would like. But with respect to health, we'll get onto that, because that sort of decisions that you want to make about your health while you're alive is sort of runs over into advanced health directives, which work together with enduring powers of attorneys. Powers of attorneys don't need to be registered, and they generally are only registered if you are buying or selling property. So the titles office, when you're registering any documents, they will make you register that document in the titles office. But if you are not dealing with anything other than property, then it doesn't get registered. So that's a question there. When does it begin? Well, that's up to you. So most people, and if you have, say, just a general husband and wife situation and you're doing your wills, we would always suggest that you do a power of attorney or an enduring power of attorney at the same time. Because if something does happen to you and you don't die, nobody can step in and make decisions for you without applying to the legal guardian to make those decisions. So often more important than your will, because that's, say, your living will. It gives the ability for your everyday activities to continue, even though you don't have the ability to do those things for you, because your incapacity may only be for a short period of time, or it could be for an extended period of time. So it enables someone to step in and make those decisions for you. The one person who you cannot appoint is a paid carer. So, and when we talk about paid carers, we're not talking about that your husband or your wife or someone who is, or your child who is being receiving a carer's pension. We're talking about an outside person who, a community carer who is paid to go to your property, for obvious reasons why you cannot appoint those. So people who we suggest have copies of those enduring powers of attorneys when you have them, your solicitor, your doctor, your accountant, your stockbroker, all of those people who, if something happens to you, they will all work together with your attorney to work out what needs to be dealt with. So without one, Queensland law enables the statutory health attorney to make decisions for you, or a relative can apply to the court to make decisions for you. So again, a simple document, a simple process protects you in the event that, and you may never need it, but it's like an insurance policy. Because if you're trying to deal with a loved one, again, who's in a bad way, and you can't make decisions for them, you have to go through the stress of trying to apply for sometimes an urgent order so that you can deal with those things. So limitations and dangers about enduring powers of attorneys is, the obvious one is that they're going to not work in the best interests of you, and spend your money unwisely or make unwise decisions. The attorney does owe you a fiduciary duty to act in your best interests, and they shouldn't ever be acting in their own interests. In fact, that is the overriding duty of your attorney. But not everyone can be trusted, so make sure you do trust somebody who you appoint. Advanced health directives, which do work in some way with the enduring powers of attorneys, it's sort of taking your enduring power of attorney to a whole new level. When you create a power of attorney, you're actually giving your attorney the ability to make decisions for you, whereas an advanced health directive gives you the ability to make decisions about how you want your medical care to take place in the event that you're unable to communicate those wishes. So they do overlap with the power of attorneys, because if there is something specific that needs to have a decision made about your health and it's not provided for in your advanced health directive, then your attorney does step in and make that decision. But the advanced health directive does take precedent over your power of attorney. So it sets out a lot of questions to deal with, and they're just yes and no answers. If you are in the late stages of an irreversible disease, do you want CPR? Do you want assisted ventilation? Questions like that, and blood transfusions and real specific questions. So you just would generally go through those questions, yes, no, yes, no, yes, no. And then you take that document to your doctor and you discuss it with your doctor, because you need to understand what the implications are. Because without an advanced health directive, the medical profession is there to keep you alive.
Yes.
So their overriding obligation is to ensure that you're given appropriate care to try and keep you alive. So if it's your desire that you do not wish to be kept alive and just be sustained, then it is really important that you have an advanced health directive, because that will override those decisions.
I can't state the importance of this particular issue over the last 10 years in aged care and community care programs to have the advanced health directive in place. It's such a valuable thing to do, and I really encourage everybody to really seriously think about it. Well,
it gives a guide to the treatment that you would like, because, and just recently, we have circumstances where people are having to make life and death decisions for somebody else, not knowing what that person's wishes would have been. So you're not only helping guide it, but you're taking the pressure off of somebody else in a really difficult situation. So again, doctors' involvement, they will make sure, if you even are just looking at an advanced health directive and you're not confident in completing it, make an appointment and tell your doctor that this is what you want to do, and they will go through that with you. Once your doctor has signed off on it, then you bring it to your solicitor and we do the secondary sign off on it. And that's where we incorporate the enduring power of attorney as well, so that all needs to be in place. So that's a little bit of a backup. So it just lets your loved ones know what it is that you would like. And some people have religious beliefs as well that would prohibit them from having a blood transfusion. So those things need to be noted, because if an ambulance turns up at your door, they don't know. And that's another important thing to consider, is if you do have an advanced health directive, keep it on the back of your door, particularly elderly people. Because, particularly in our community, I know that that's where people look. And even in the village here, that's where people look when people are in their units, is if an ambulance arrives, they will look to see if there is anything on the back of your door. Because if you need CPR, that ambulance officer is going to do that before even your loved ones know that anything has happened to you, to say, oh, hang on, we've got to do not resuscitate. So keep it somewhere, make sure your doctor's got a copy, make sure your solicitor, and also people who you live with, to know where they are. So that's the extent of advanced health directives per se. But that's where you can really put the wishes of what you want done for your medical treatment.
Very important. Thank you very much, Riki.
No problem at all.
A couple of questions have come through. Who can contest your will, or a will, I should say, not yours?
Contesting wills, that's a great one. We love we love questions about contesting wills, because it is a very difficult area of law. In that a lot of people don't understand what or what gives people the right to contest a will. So contesting wills, generally speaking, if you leave out a child in your will, that's the biggest thing that we see, is that there might have been a relationship breakdown throughout the life of your children, and all of a sudden, once somebody passes away, that person's pops up to say, I need a hand. So somebody, definitely any child or children of a deceased who hasn't been given sufficient allowance for in their wills, but there are rules that need to be followed, and somebody who's contesting a will does need to prove a couple of things. One is that there has to be that relationship that they have. So, for instance, I couldn't just come and contest your will because we have no relationship. You've got or no reason to have left me any benefit in your will. So a relationship, and also need. The person needs to. So if you want to contest a will and you are financially stable in your own right, it would be difficult to have a claim to contest a will. Actually, I should just clarify something when we're talking about contesting wills, because there's two different issues that people do get confused with. When you contest a will, you're contesting the validity of the will. So that is, for instance, that person did not have capacity when they created that will, and therefore it's invalid. When people generally are talking about contesting a will, it's not called contesting a will, it's making a claim for further and better provision under the Succession Act. So it's a little bit different to what people generally say contesting a will. So the Succession Act will provide who is capable making a claim and what they need to do to be able to make a claim. So if you think that if there's somebody who should probably morally be receiving a benefit under your will, then that moral obligation will generally show that that person will have a right to contest your or make a claim against your estate, for sure. And one other common thing that people ask when they're talking about making a claim against somebody else's estate is, oh, I'm making a will, let's just give that person $1 and they won't be able to make a claim. And that is completely incorrect. So when we're looking at making a claim under a will, it also it depends on the size of the estate. It depends on how many other beneficiaries are involved in the estate and what their financial positions are and how they might be affected by the court coming in and giving somebody else money. So each particular situation is completely different, and again, good to get really good advice on that before you make any decisions.
Right, thank you.
It's very costly to make claims, and if you're found to be making a claim and you're pursuing it, and you really do not have the legal grounds to be making the claim, you and also the solicitor who's acting for you in that regard can be made held responsible for not only your own legal costs but also the estate's cost in defending that claim. So
kind of like that.
yeah. Well, it can work the other way as well, but yes. It's about we not many of them will actually get to the stage of going to court unless they're worth a substantial amount of money, because the cost involved is so significant. Between different lawyers and their clients, we do look at what it would look like from looking at precedents as to what that person might be entitled to, and then we try and work out a compromise, because no one wants to be spending the people's inheritance on legal fees. So
sure.
First point is, let's try and solve it between the parties. If we can't solve it, mediation is required, and then the last instance is court.
I like that. Another question for you. How do I provide for pets? Your pets?
Pets. Oh, yes. Okay. Well, pets, unfortunately, are classified as assets, and so you can gift them in your will. And you might want to make provision for their care for a financial amount. But you can definitely put your pets in your will and what your desires are in that regard.
Have you had an example yourself?
Yes, we have a few examples. With respect to some people will wish for a particular person to take that pet. If that person, but then we also have like little backup plans. So if that person doesn't want it and the executor can't find a suitable place, then there are animal rescues in the community who will actually help to rehome those pets, and some even people who live in the community and they don't really have anybody else who might look after their pets or even know. There's actually places where you can register so that people can make contact with those places and come to your property and collect your pet, you know, once they've been notified that you've passed away, so that that pet is looked after straight away from the beginning.
Okay, thank you.
Because they are like family.
Absolutely. Yes. When does an enduring power of attorney take effect?
Well, I think you can have it take effect with respect to financial matters at any stage. So they will start either immediately or when you become incapacitated. Now, that also just reminds me to discuss about ending the power of attorney. Right. Because an enduring power of attorney, you can revoke it at any time. So if you've appointed somebody and for some reason you've had a disagreement or you've lost faith in that person, or you've divorced that person, then definitely we need to revoke that power of attorney. And as long as you have capacity, you can revoke it at any time and create a new one. So if we revoke it, we just give notice to the person, although it's not essential, but obviously you don't want somebody acting on that power of attorney when they haven't received notice that it's been revoked. So that's also something to consider. If you are nominated as somebody's attorney, you sign to say that you accept that in the document. If for some reason you change your mind, you can only withdraw while that person still has capacity. If you want to withdraw after that person has lost capacity, you have to go to the court and get their authority to withdraw. So it's really important when people say, will you be my attorney? And they go, yeah. Think about what that actually means, because it can be a really heavy burden on somebody, and it's an unpaid burden. So even though a lot of people will think, yep, I'm happy to step in, some people don't realise what actually that's going to entail.
Some responsibility there.
A lot of responsibility.
Fair enough. Another question, what's the difference between a statement of choice and an advance health directive?
Statement of choices are really something that the hospitals do use more commonly these days, and it sort of just gives a statement so that the hospital and the people around you generally have an idea about what your wishes will be. But we would still recommend the Advanced Health Directive be entered into in that regard, because that's what we deal with on a more common basis. Those directions are quite new. I don't think they've been using them for that long, but it's not something that goes through the proper channels in having the doctor's compliance.
That makes sense. I know through my own family's situation that we tossed around regarding my little old mum again, if she should have the will and then the Advanced Health Directive and the enduring power of attorney. And we eventually ended up with all three. Do you recommend that?
Of course, yeah. All three definitely is going to give you the best protection, and it's going to give the people who you want to administer your affairs the legal right to do that. Of course, do one, three is going to be great. At the very minimum, a will and a power of attorney.
Yep.
Yep.
Yeah, that makes sense. Look, I don't think we have any other questions at this moment in time. So thank you all for tuning in for our webinar today. As this is the second webinar in our series, we have a number of interesting and informative speakers for the remainder of the year coming up. The webinars are held on the last Friday of each month with Sarah Locke from Churches of Christ Community Care, discussing accessing in-home care. This webinar will be held on Friday the 28th of August from 10 a.m. to 11 a.m. For more information, please head online to www.cofc.com.au/webinar. Thank you very much again, Riki, for coming in. It's been a real pleasure to have you here.
Thank you. Thank you.
And good morning, everybody.